All right, we're live. I'm attorney James Betzold. Welcome back. We're going to be doing this first one in English. Okay, so for all of mis amigos que hablan español, you have to wait a little bit. Tienen que esperar un poco y ya voy a hacerlo en español. This one's English. All right, let's get some people watching us. First of all, please put any questions you have in the comments. We had some brand new things happening with the U visa process. Released these details today. It's brand new. It has a lot to do with some of the federal litigation we've been doing and supporting and helping others with throughout the country. We here at Betzold Law, we have actually taken on a lot of U visa cases. So we have probably over the last decade or so over 120 or 130 pending U visa cases. And the biggest problem with the U visa is how long right now it takes to get any sort of work permit or work authorization. And so what's changing now is we're going to pull up on the other screen here in a minute some of the details that deal with that. What's changing is how quickly, hopefully, you can get a work permit. So under the law, there's this thing called a bona fide determination. And the statute says that anyone who's applying for this visa who has a bona fide case before the agency, bona fide, just a fancy Latin term, that means, who knows what it means? Put it in the comments. Let's hear comment. I see 7 people watching. Does anybody know what bona fide or bona fide means? I'm watching the comments now, so let's see if that comes in. Whoever posts the correct definition or an acceptable definition of bona fide first, I'll send a t-shirt to. I'll have my daughter send a t-shirt to you. All right. So give me your t-shirt size with that answer too. Bona fide, I'm not going to tell you. We're going to answer that later. But anyways, when they make a bona fide determination on your case, they're just checking to see that you have the application and it's been filled out. They're checking to see that you have the certification from the local police department or whatever law enforcement agency certified your case as the victim of a crime. There we go. We got a Facebook user. It means legitimate, genuine, met all the elements. That's weird. You're just showing up as Facebook user. So I can't send you a t-shirt. Tell you what, Facebook user, send me. I won't post it, but if you want to send me or post your email, then we can make the arrangements to get you that, because that's right. Bona fide is like legitimate, genuine, met all the elements, or completed in good faith. So that is a good answer. So what it means is the statute says if you've got a bona fide application, then the government can give you a work permit. They may give you a work permit. And of course, they're using that terrible permissive language, like they can do it, but they don't have to. So what they're doing now is they're going to say, yeah, we know we don't have to, but now we're going to start doing it. And I think it's pretty interesting to read some of the comments that the government made with the announcement of this new policy. All right, Sharon Leona, thanks. Let's make sure you friend me or something so I can get a way to contact you so I can send you that t-shirt. And your t-shirt size, you don't have to put it here. We have, I think, anywhere from small to extra large, or maybe extra. Do we have any, Emmy, do we have any extra larges? Go to the t-shirts in the closet. Let's find out what the largest and smallest sizes are. We maybe only medium or large or something. Yeah, either of them. All right, so we're checking on that t-shirt situation right now. Right, so they're saying now, even though they don't have to, they can, and so now they will be doing that. And they're doing what they're calling a bona fide determination. Again, let's be clear. As someone who's litigated these cases in district and now in the Sixth Circuit Court of Appeals, the government already does this sort of bona fide determination as soon as you file this application, because they're looking to see, oh, is it complete? Do we need to reject the application or can we accept it? And if they reject the application, well, it doesn't meet the minimum requirements, so it's no good. So really, when they're looking at this, the first things that they do is they check if it's complete, they issue you a receipt, and then they go send it off to do the FBI background check. So your criminal history check gets done. And in the published notes, what they're saying right now is when that's done, that's good enough. That's going to mean essentially that it's bona fide, as long as you're not a national security threat on top of that. We do have extra large shirts. Okay, so tell us your size up to extra large. We can send that. So that's interesting. Now, what's also interesting, and in fact, let me put up, I got to share a separate window here. And I got to do just a little bit of, here we're going to share screen. Sharing screen is easiest with 2 monitors. I know, let's share screen. And we're going to actually just share the window. Here we go. Sharing. All right. Now you can see it. Let's take a look. Let's open. Here we go. Oh, this is pretty neat. All right. So if you go to the uscis.gov website, this is the website for the main agency that is tasked with making immigration decisions, immigration benefit decisions. So like they're saying here, here's the guidance. This is the new guidance under Chapter 5, which was published today. There is this new thing, a new process. They just made it up called a BFD. I'm assuming they mean bona fide determination, but it's going around the attorney community as big effing deal, because it is a big deal that they're actually publishing their policy on this. So during this process, like we were just talking about, is it really complete? Is the application complete? Is there certification, the official statement from the applicant, and is the form filled out correctly? You get those 3 things. They can then determine whether you've committed any crimes by checking your background. And if you pass that, then they will issue you a work permit. And here's the thing. Over the last 10 years, people have been sending in work permit applications with these under different categories. There's A14 or A20. So there's a couple different categories you could file these under, whether you're the primary applicant or a derivative beneficiary or something like that. Well, what happens is over the last 10 years, they've even changed the policy on when to file the work permit application, how to file it. Does it go with a fee? Does it go without a fee? So what they've said here is they're going to use any existing work permit application that has been submitted already as a way of lessening the administrative burden. Otherwise, you're going to have lawyers like me scrambling with over 100 clients saying, well, let's file one more form, even though we've waited 5, 6, 7 years already. Let's file one more form and pay one more fee. But again, they talk about the bona fide determination. Let's see here. All right. I thought I got another comment. I didn't know if it was an attorney saying they wanted to jump in. Got a lot of attorney friends. If you're watching this, if you get this, put something in the comments. We'll talk about it, because I'm not the only person out there qualified to talk about this for sure. Qualifying family members, it's going to help those qualifying family members as well. Again, they're going to look and see if you're a national security threat, and then therefore not worthy of the discretionary grant of a work permit. Because again, like the government said, they can give you one if you have a bona fide application, but they do not have to give you one, they say. Some attorneys would disagree. But now what actually they've done is they've really defined how they're going to use their discretion. So in the future, barring any major changes in the administration at USCIS or the presidency or a new administration who tries and throws this in the garbage, what they're saying is, here's how we're going to use our discretion that the statute gives us. So if you meet all these criteria and the government still turns to you and says, no, you do not get one, then you can sue and you can say, well, this is how you use your discretion, and I meet that, and you're not doing it to me. So now you're being arbitrary and capricious, and I'm going to sue you under the Administrative Procedures Act for acting arbitrarily and treating me unfairly. So that's actually really important that they put this in words now. So they've defined for the world what their policy is and how they're implementing it. Here they're talking about the adjudicative process. This again is talking about how they're going to review it initially, like they already do, as was revealed in some litigation documents. Not my cases, but other cases that have happened. And then if they're given the bona fide determination work permit, they don't need to go on a wait list, because everybody's going to be waiting anyway for for the actual U visa to become available for them. Those who are not given a bona fide determination are then put into the waitlist process where they do a more in-depth view and say, hey, is this really going to be approved or not? And you could end up with someone getting denied then, I suppose. Sounds like. All right, let's, okay. And of course, like they said, they're going to be doing a criminal history background check. All right, so that's important. Previously filed I-765. That's the work permit application. So if you previously filed one in conjunction with the case, here we go, like under A19, C14, A20, or C14, those are going to be able to be used. You don't have to refile it. So apparently once they start doing this BFD review for everybody, which honestly, they've done. They know if there's a case there with something missing. That happens when they begin the case, when they issue that receipt to let you know it was received. Okay, there we go, there we go. And then, again, we see this terminology popping up again, because it used to be they would give you a prima facie approval notice or a prima facie determination. You may call it something else. I call it prima facie. It's Latin. I'm saying it right. So just meaning that it's sufficient on its face to be approved. Now they're officially recognizing it. This is interesting because in some of the federal court litigation, the federal government, USCIS, was saying, oh no, we don't do there's nothing that exists called a prima facie determination. This doesn't even exist. It did exist. And once again, they're recognizing that it exists. So that's pretty interesting. All right, let's keep moving. Waiting list adjudication for petitioners. Yeah, we talked about the waiting list, how that will happen. And then, so this work permit is going to be good for 4 years, which is important because it's taking over 10 years to go from filing it to getting your U visa approved. It's actually up to 12 or 13 years wait now. So you'll get that initial 4-year work permit and you'll be able to renew it as well. Now, if you're granted it initially, it doesn't guarantee you'll be renewed. If you get the initial grant, but then you go out and commit a bunch of crimes, they're going to have the option of not renewing that for you. So definitely, it doesn't give you any special status or protected status. It just lets you work, live, not get harassed by immigration, get a driver's license, get a social security number, but you still have to avoid any criminal convictions or other immigration violations because it can be revoked, right? At any time they get wind that you're doing something illegal, they could say, we're revoking it. They could take away your work permit as well. All right. A lot of that other stuff is really sort of common sense. Let's go to, oh, well, we may be able to touch on this. If you're a U visa applicant and you're outside the United States, this doesn't help you. It doesn't do any good. If you're outside the United States and you're a U visa applicant, you need to just stay and wait until you can go to your consulate and actually get the visa, which, like I said, is a many-year process at this point from start to finish. All right. Now, what I thought was really interested in reading this was some of the, well, let's see, is there an update? Yeah, look, here's a policy alert. This is really what we're talking about today. Appendices history. There's no appendices available right now. Let's refresh. Sometimes that'll, yeah, see, there's actually 2 now. So they're actually in the process of updating their website right now as well. And I thought this was what I was reading earlier, so it may have been gone and back. Let's check resource. These are some of the citations to the different parts of the law and the forms needed. All right. So in the appendices, let's look at this. Bona fide determination process and Administrative Procedure Act considerations. Now, it's interesting. They're already saying, hey, we know there's this thing called the Administrative Procedure Act. Why do they know that? It's not because they're the government that they know that. It should be the reason, but it's not. If we look down, you know, it's really neat. When we file a complaint and the government files an answer or a motion to dismiss in these federal cases, pretty much word for word, this is the language that appears, whether it's from the attorney or from the government repeating it back. They've always got this, okay, here's the historical background stuff. So it's neat that they're putting it here too. And you can see here they talk about 214P6, subsection 6, which they say does not require the agency to create a separate employment authorization process. That's up for debate. However, because of drastic increases in the volume of non-immigrant petitions and a growing backlog, USCIS decided to exercise its discretion to conduct bona fide determinations and provide EADs and deferred action to non-citizens with pending bona fide petitions who meet certain discretionary standards beginning June 14th, 2021. That's today. So this is brand new information. And they know about, like, this has been called to their attention recently and to their attorneys, the Attorney General of the United States' attention, because this is one of the things we're suing under, was we're saying, look, our clients filed a bona fide application. It had the full application. It had their statement. It had the certification from the government, and it's not a lie. So you should give them a work permit, because poor things are going to have to wait 10 or 13 years before they can get any sort of relief from this application process. And there's a way to do it, so they should do it. So now it looks like they're taking that seriously. Okay, then some other citations here. They're reciting some of the statistics. And one of the things that the USCIS will always do is they'll say, oh, look at us, how difficult it is for us. We have so many people applying. It's so difficult for us to do our job. It's so hard. They're the United States government. They have money. But what they'll say, not only in litigation, but here in this notice is, well, look at the numbers. They go up, 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 et cetera, et cetera. It's very complex. There's a pending backlog. The delay, they say, but they've never showed anything to really prove this, is due to the increased number of filings overall, the complexity of adjudication, which it is not complex. I mean, we're talking, you go down a checklist and you can approve these cases. They say the statutory cap mandated by Congress, that's true. Only 10,000 U visas are allocated per year, which is very small. And then they say, and the agency's priorities and limited resources. Well, excuse me. You're the United States federal government. You have unlimited resources if you need it. Why? Because your agency head can always go back to Congress and say, Congress, we need money. And Congress can give them money. And that's not unheard of. So when it's needed, especially to protect victims of crimes, you think it would be a sympathetic call. Anyway, so they say, oh, we're USCIS, but we're unable to adjudicate the tens of thousands of petitions for the waiting list, as well as full adjudication for the 10,000 principal visas. Now that's interesting. So they're saying they can't even do the bare minimum of their job, no matter what they do. So they say, taking that into consideration and numerous adjudications, we got to do something different. And so they're explaining why they're implementing this bona fide determination process. It says, additionally, as of June 14th, we're facing substantial litigation. You're welcome. All right, so let's do some shout outs. Let's do a shout out to attorney Bradley Banias of Wasden Banias out east, over in Boston. Brad put on a great training for U visa litigation not long ago. So we definitely owe him a shout out. And he's been helping actively and is actively co-counsel on some of our on the appeals that we have pending in the Sixth Circuit Court of Appeals. So the government here is saying, additionally, look, we're getting sued. We're getting sued over and over. And sometimes the government's losing. Sometimes the attorneys are winning, which is great for us and for our clients. And what happens is having to deal with all those lawsuits puts a burden on the government. It puts a burden on the USCIS, because now they have to have people who are like, not collaborating. What's the word? Like, there's a neat French word for this. What is it? Like a liaison. They need to have like a liaison officer at USCIS who works with the Attorney General's office, who works to help move this litigation along. And then when they lose those cases, they have to issue those work permits anyway. So what they're saying is here, that's an additional cost, and it's fueled. They recognize it's fueled by the years-long wait times for petitioners to be placed on the waiting list, which is usually the only time they would get a work permit. And then, of course, to obtain U status, because of the number of new petitions filed each year. So what they're saying is there's all this stuff going on, including this substantial litigation. Yes. Yeah. Thank you for your time, Eduardo Sosa. Yes. Thank you, man. Thanks for watching. We got him here right here. Let's recognize Eduardo Sosa. Thanks for watching us on YouTube, buddy. We appreciate it. We'll do this in Espanol in a little bit too. So let's go back. Let's take a look at some of the other comments because there's a couple other interesting things they said here. USCIS recognizes concerns regarding such vulnerability raised by stakeholders and believes implementing the statute's authorization to provide EADs to those with pending bona fide petitions better aligns the U program with its dual purpose as envisioned by Congress, stabilizing victims of crime and serving as a tool for law enforcement. And they're absolutely right. This is exactly what we're saying in the litigation that's taking place in the federal district courts against USCIS for taking so long to do this. For this process has been authorized by statute since the beginning, since the beginning of law. So it's great that they're finally doing it. And I'll just point out that Donald Trump isn't president, and Barr is no longer attorney general, and neither is who's the Jeff Sessions, the gremlin? Is that what we called him? Elf? Whoever he was. That guy who was no help as attorney general. They were actively trying to prevent these things. And of course, now we have Alejandro Mayorkas, the new head of USCIS, who himself, son of immigrant, Cuban immigrant himself. So I think a lot of that is helping. Definitely, yeah. Look at this. Look at this. Like you, Samantha, Eduardo, this is going to help you. Been waiting 4 years to get your U visa approved without an employment authorization card. It's tough. It's hard, right? Like, you're here. They won't deport you, typically. But you can't get a social security number unless you already had one. You can't get a driver's license. You can't have access to typical health care. I'll bet you can probably get a vaccine. They'll probably let you go into Walgreens and get that without a social security number. But pretty much everything else is just tough. I mean, and you've got a number of individuals who have been victims of really severe crimes. And it's like, okay, yeah, we'll help you fill out this paperwork, file a police report against the people who did this to you. We'll be here to support you. But a lot of times the criminals are in prison and out of prison before the victim can even work legally. Impossible situation. So this is definitely a step in the right direction for USCIS. Let's look at some of the other interesting things they say. Well, and you know what? They recognize the concern and yada, yada. That's true. And they recognized the concern back in 2000, and it was either 2007 or 2011 or 2013 when USCIS created the waiting list. If you go and read the regulations where the USCIS says, okay, that's too much. We're creating a waiting list. We're going to apply these people first. We're going to do these people next. They said they had really three options. They could say everybody applies 1 year, and those who are above the number who come in later automatically denied. They have to file again next year. That was one option. They rejected that option, right? Another option was, well, we're going to have everybody who files, and then when we get above the limit, we're going to everyone's files, and then we're going to see who's the most sympathetic case. And then the more sympathetic cases will approve, the rest will get denied, and they'll just have to refile the next year. So you would have a situation where you had to keep refiling. And USCIS settled on option 3, or the third option, where they said, we'll just create a waiting list. Everybody files, stand in line, first come, first serve. We're not going to worry about who's more sympathetic, who's less sympathetic. And they said, we're going to go with option 3 because it's going to create so much hardship for everybody else. It's going to create an administrative burden. It's going to be unfair if we're trying to decide who deserves it the most, because all of them potentially would qualify under the statute. So they're recognizing this again, now that we have a rational presidential administration or executive administration in the White House. I think that has a lot to do with it. They definitely wouldn't be doing this if former Donald Trump was currently president. So that's, for immigration, this is wonderful. All right. And it says, yeah, it helps it to be more efficient, provide benefits and deferred action to more petitions in a shorter time frame. And generally speaking, overall, 75% of the people who applied for a U visa were ultimately approved. So it's one of these categories where there is a higher approval rate. So it's important to run these through more quickly. They talk again about what it means to be bona fide. That's in the official wording that we already read. And let's see here. This talks about, this is the Administrative Act procedure considerations. And they say, yes, under the Administrative Procedure Act, we have to do this in these circumstances, and we can just do a notice in these other circumstances. So they're giving their legal justification for doing that here. Now, I don't think we're going to see anyone from the immigration attorney bar try and sue the government about this. Let's hope nobody else tries or nobody else gets any traction on it. And I don't think they really have a leg to stand on, because this has been the law for a long time. They're just now deciding in their administrative grace. Hold on, let me say it like this. USCIS has decided in their administrative grace to finally implement something that was for a long time provided for in the law. Okay, that's the sweet radio voice for everyone out there. All right, so again, they're saying because this is really just implementing existing law, there's no other regulatory procedure to follow, like posting a notice and getting comments and taking feedback. They don't have to do that. I agree with that from a legal standpoint. It seems like a smart thing to do. Alternatively, if somebody does file a lawsuit and challenges it, we have plenty of pending lawsuits that the government can settle with us, where they could make this a term of the settlement as well if it were needed. But again, I don't think that's probably even needed. Okay, so this is some other things where it talks about where people shouldn't have to deal with unfair surprise or administrative burdens. There is really none of that. It's just a huge benefit for people who are applying for U visas at this point. Some of the comments here about how they're going to implement that. Here we go. It's just real soon. USCIS began implementing this policy June 14th, 2021. This policy applies to all petitions pending on June 14th, 2021, and all Form I-19, that's a U visa petitions filed on or after that date. All right, so it's all inclusive. If you've already filed it, awesome, you'll get this. If you haven't filed yet, but you're going to file tomorrow or in a month or a week, this will also apply to you. So I think, boy, this is huge. This is even, this feels some considerations for some more of our clients, I guess, who have a legitimate U visa claim, but maybe have been hesitating just because it would be 5 years before they could get a work permit, maybe. Now, I'll just publicly here note that they didn't promise any particular time frame. So they're not saying we're going to review this in a month or 5 months or 4 months. But it looks like, from what they're saying, if you file it, they send that receipt to you. That's what they've done up to that point is enough for it to be called a bona fide determination. So I think there's some really, this is probably the most monumental thing that's happened on U visas in a long time. And you know what? Thanks to everybody who filed a federal lawsuit. Thanks to all of our clients who allowed us to file a federal lawsuit for them on their behalf when it comes to this. Thank you to all the other attorneys who've supported our firm and that we've been supporting in this process to help get more attorneys litigating in federal court, so that we can push for these sort of changes. I mean, you see right here, it says, look, additionally, USCIS is facing substantial litigation fueled by the years-long wait times for petitioners. That's music to my ears. That makes me feel pretty good about some of the tough cases we've taken on in the last couple of years. And this is great news for victims of crimes, right? So if you've been a victim of a crime, if you're suffering from domestic violence, a violent assault, something like that, and you don't have status in the United States, this means that potentially right now, you're going to be able to get a determination on your work permit more quickly. So we're not going to have to wait. The current published times, which are 57.5 months, that's over 5 years, or it's at least four point something years. It's a long time to wait. And it's untenable for many people. So this is good news. This is good news for people all around. Let's take a look at the other appendix here, the other appendix, bona fide determination process flowchart. Ooh, let's open a PDF. Let's see. Yep. Okay. So it shows here. All right. So let's look. I'm going to take a look at this live with you right now. Is the 9118 properly completed and signed? Yes. Is the certification properly completed and signed? Yes. Does the filing include a signed statement from the petitioner? It should, because it's a requirement of the U visa, where they say, I was a victim of this crime. This is how it affected me. This is why it sucks so much. This is why I need help. This is why I need a work permit. This is why I need help with a visa. And then, has USCIS collected biometrics from the principal petitioner, right? So had they have their fingerprints taken? This is a requirement. After you file the application, they send you that notice saying, hey, go get your fingerprints taken. Have they collected it? If all that's yes, okay. Then may USCIS issue the determination? Well, has the officer determined that they filed a complete form? Yes. Has USCIS reviewed it? Yes. Should USCIS exercise discretion? Like, are they a terrorist or national security threat? Right. Not. So then, yes, you would receive the work authorization and deferred action. And then you're placed back in receipt date order into the queue for adjudication of the full benefit. Fantastic. That's what we've been suing for the longest time, except we've been suing for them to do this and recognize it more quickly, which it looks like they're doing. All right. Do we have any other comments? I don't see any other comments at this time. I'll thank you for joining us. So I'm attorney James Betzold. Let's see here. We got our website there, visafeliz.com. We also have other websites, right? That's sort of our Spanish branded site. Here's Abogado James Betzold. That's my phone number. If you're seeing this, you know how to get a hold of me. You have Facebook, you have YouTube. If you need help going through any immigration process, we are here to help you. We have a lot of free information on our webpage. If you go to visafeliz.com, you're going to find a lot of free information. You'll find this video there as well. What's my goal? My goal is to promote the access to justice, both to the end client and to attorneys, right? So I see it as one of my purposes in life to help other attorneys help their clients, and for me to help my own clients get justice and get access to things like a work permit when they're eligible for it, or a family visa, or a visa for someone who's a victim of a crime, or some other family petition. So that's our purpose. That's what we do. Please find any way to get a hold of us. Facebook, put your comments in there, send me a direct message, friend me, say hi to me, like any of these pages that we're broadcasting on, either Betzold Law or Prima Immigration Lawyers, visafeliz.com, Bella Legal Assistance. We have our legal assistance, our legal assistant company, paralegals for other attorneys out there as well. Federal Court Immigration Lawyers. If you're an attorney, I encourage you to join that. We'll help support you in your federal court litigation. And that's all for today. Thank you for watching. We appreciate when you share this.